Interlegal world is presenting with litigation course. Litigation allows people to settle disputes that they have been unable to do on their own. Hence, this litigation course will help you to understand the risks, alternatives, and the realities of the major stages of litigation. By looking through case studies, you will understand litigation comprehensively. Moreover, this course will help one flourish and attain an in-depth legal knowledge related to litigation. You will also explore the essential technical information and have the opportunity to put that into practice through skill-based exercises. This course offers a solid grounding in the litigation course, additional reading and discussion on amendments to laws and recent judgments, complete coverage of laws including CRPC and other special statutes, stimulation exercises based on recent developments and actual case laws, anecdotal discussion by our industrial academia panel about their experience in handling civil cases. Online classes will be on weekend evenings for 2 hours. Recordings for lectures will be provided. Certificate of participation to everyone on completion of course. Certificate of merit on 60% attendance and 50% assignment submission. Confirmed internship for meritorious students under senior advocate and litigation firms. In case a landmark judgment is passed by Supreme Court that shall be discussed apart from the syllabus. The idea of this course is to equip students with fundamentals of criminal, civil, and constitutional laws. This course is a combination of practical execution and interpretation of various statutes of law. So what are you waiting for? Grab this opportunity. Interlegal world is presenting with litigation course. Litigation allows people to settle disputes that they have been unable to do on their own. Hence, this litigation course will help you to understand the risks, alternatives, and the realities of the major stages of litigation. By working through case studies, you will understand litigation comprehensively. Moreover, this course will help one flourish and attain an in-depth legal knowledge related to litigation. You will also explore essential technical information and have the opportunity to put that into practice through skill-based exercises. This course offers a solid grounding in the litigation course, additional reading and discussion on amendments to laws and recent judgments, complete coverage of laws including CRPC and other special statutes, stimulation exercises based on recent developments and actual case laws, anecdotal discussion by our industrial academia panel about their experience in handling civil cases. Online classes will be on weekend evenings for 2 hours. Recordings for lectures will be provided. Certificate of participation to everyone on completion of course. Certificate of merit on 60% attendance and 50% assignment submission. Confirmed internship for meritorious students under senior advocate and litigation firms. In case a landmark judgment is passed by Supreme Court that shall be discussed apart from the syllabus. The idea of this course is to equip students with fundamentals of criminal, civil, and constitutional laws. This course is a combination of practical execution and interpretation of various statutes of law. Litigation allows people to settle disputes that they have been unable to do on their own. Hence, this litigation course will help you to understand the risks, alternatives, and the realities of the major stages of litigation. By working through case studies, you will understand litigation comprehensively. Moreover, this course will help one flourish and attain an in-depth legal knowledge related to litigation. One will also explore the essential technical information and have the opportunity to put that into practice through skill-based exercises. This course offers a solid grounding in the litigation course, additional reading and discussion on amendments to laws and recent judgments, complete coverage of laws including CRPC and other special statutes, simulation exercises based on recent developments and actual case laws, anecdotal discussion by our industrial academia panel about their experience in handling civil cases. Online classes will be on weekend evenings for 2 hours. Recordings for lectures will be provided. Certificate of participation to everyone at completion of course. Certificate is merit on 60% attendance and 50% assignment submission. Confirm internship for meritorious students under senior advocate and litigation firms. In case a landmark judgment is passed by Supreme Court that shall be discussed apart from the syllabus. The idea of this course is to equip students with fundamentals of criminal, civil, and constitutional laws. This course is a combination of practical execution and interpretation of various statutes of law. So, what are you waiting for? Grab this opportunity. Interlegal World is presenting with litigation course. Litigation allows people to settle disputes that they have been unable to do on their own. Hence, this litigation course will help you to understand the risks, alternatives, and the realities of the major stages of litigation. By working through case studies, you will understand litigation comprehensively. Moreover, this course will help one flourish and attain an in-depth legal knowledge related to litigation. One will also explore the essential technical information and have the opportunity to put that into practice through skill-based exercises. This course offers a solid grounding in the litigation course, additional reading and discussion on amendments to laws and recent judgments, complete coverage of laws including CRPC and other special statutes, simulation exercises based on recent developments and actual case laws, anecdotal discussion by our industrial academia panel about their experience in handling civil cases. Online classes will be on weekend evenings for 2 hours. Recordings for lectures will be provided. Certificate of participation to everyone at completion of course. Certificate merit on 60% attendance and 50% assignment submission. Confirmed internship for meritorious students under senior advocate and litigation firms. In case a landmark judgment is passed by Supreme Court that shall be discussed apart from the syllabus. The idea of this course is to equip students with fundamentals of criminal, civil, and a very warm welcome to everyone presenting to the last day of the bootcamp. So it is an immense pleasure to welcome you for this bootcamp which is organized by Interlegal World. I also welcome the speakers for this bootcamp. I welcome Advocate Tane Hazari sir, who has who is a practicing advocate in Lucknow High Court. Earlier, who was working with the law firm in Delhi. He was the counsel of Canara Bank, Hyundai India, National Insurance Company, and many other companies. He also belongs to a family of judges and advocates. He is a fifth generation lawyer, and he is a former international table tennis player and the state level chess player. He has also written 3 mystery novels. So I welcome Sir to this bootcamp. So the topics to be covered for this session are concept of Writ and PIL. So once again, I welcome you to this bootcamp. Hope you have a wonderful and an informative session. I hand over this session to Tanay Hazari.
Yeah, hi everyone. I hope I'm audible.
Yes, sir.
Yes. So basically, the topic is Writ and PIL. So basically, I would not be dealing with any theoretical aspects with regards to this topic. See, theory is something which you can always read in books of law and also in the regular lectures which are taken and delivered in classes. Now, with regards to the practical aspect of this topic, I would like to deal with. I have in the past delivered lectures. I have had the option to deliver lectures to students of IIM Kozhikode and NLU Delhi as well, and RGNUL Patiala as well. I am a 2013 pass out of RGNUL. Hello, am I audible? So basically, yes.
Yes.
So basically, in as much as the practical aspects of writ petition and PIL are concerned, a writ petition is basically filed under Article 226 of the Constitution, right? Whereas when a person is getting a right by means of writ enforced in Supreme Court, that is by means of Article 32. Now the other difference between Article 226 and Article 32 of the Constitution is that in Article 226, that is the writ jurisdiction of the High Court, you can not only get your fundamental rights enforced but also your legal rights. Now, this is a privilege which is not with the litigants when they approach the Supreme Court under Article 32. Now, my point is that everybody would be wondering, because as I have been told, the students are from first year to fifth year. So, some of you would be wondering as to what exactly is a fundamental right and a legal right. See, the basic difference between a fundamental right and legal right is fundamental rights are enshrined in the Constitution. They have been written down. They have been uh, explained in various judgments of Honorable Apex Court as well as various high courts. They are from Article 14 to Article 35 of the Constitution. Now, in as much as the legal rights are concerned, the legal rights are something that emancipate from basically a statute, an act of legislation. So anything that is any right that is being derived out of a statute is a statutory right, is a legal right. Now, a very basic example is by means of Article 21 of the Constitution, right to life and personal liberty has been granted. Now, that is a fundamental right. Okay. So, if somebody is violating your right to life and personal liberty, somebody has arbitrarily put you behind bars, or somebody has curtailed your liberty, and if that somebody is state, or if state has the power to remedify it, then one can very well approach the Honorable High Court under Article 226 and invoke its writ jurisdiction, the right being infringed under Article 21. Now, the example of a statutory right is something that has been guaranteed to you by means of an act of the Parliament. Now, the, there are basically 5 writs, but the most important and the most and the ones which are used more frequently than any other writs are mandamus and certiorari. Now, I will not be dealing with any bookish definition here. I'll be just that you can read from the books that your teachers will explain you at some point of time or the other. I would basically be telling you the practical aspects about these two writs which are very much in use. Now, certiorari is with regards to quashing of an order. Certiorari is with regards to quashing of an order. And for that purpose, once you approach the High Court, then, and that order has to be, then that order is primarily the order of an administrative authority or even a quasi-judicial body for that matter. Now, once you're approaching the Honorable High Court, any Honorable High Court, by means of writ of certiorari, then you have to highlight, then one has to highlight the illegalities that are there in the said order. Mandamus, on the other hand, certiorari, the basic meaning is to quash. Mandamus, on the other hand, is used for the purpose of enforcing a right. Enforcing a right which some particular agency, some particular government agency is not doing. For example, I'll give you an example. There is just imagine, I mean, you are living in a particular city and in a particular society, and then there's this arbitrary order. That has been passed by the learned DM of that city, saying that such and such areas in your colony will be closed. You can't move out from those particular areas. You can't just go, and then you get to know that that particular area has been uh, notified as a garbage dump. Then you check the law, you check the legal aspects, and then you get to know that that place cannot be a wasteland, because that is some place that is inside the colony, inside a residential colony. Then you see the basically then what you do is you see the basic provisions, you Google up the provisions, you see the relevant acts, the relevant provisions, and thereafter you come to the conclusion or you formulate an opinion that such particular notification by the DM is illegal. So then you have the liberty to charge such notification of the DM by means of a writ of certiorari in a in a in the High Court, right? So secondly, what can happen? Secondly, what happens is that, I mean, the similar situation. So I hope you got how a writ of certiorari is filed. That's against an illegal order. I was told my voice was not clear, hence I'm reiterating. So if there's an arbitrary notification by the DM or the municipality of opening a garbage wasteland inside your residential colony, then under such circumstances, if you formulate an opinion that the said order is illegal based upon certain aspects of law, then you have the liberty to approach the Honorable High Court by means of writ of certiorari. Right? Now, on the other hand, similar situation arises whereby there's no notification by the DM, but a garbage wasteland is being dug out inside the premises of your colony, inside the very premises of your residential colony. Then what do? There's no notification, there's nothing that you can challenge. Then what do? Then you have a remedy of approaching the High Court by means of the writ of mandamus, which says do it. right? So these are however, the basics of litigation of the High Court, which is with regards to the writ jurisdiction, basically. I mean, I, I mean, today I had some paucity of time. That is why I had curtailed my speaking time from 1 hour to half an hour, and half an hour is too lesser time to educate you people or inform you people about the practices, the jurisdiction of the writ jurisdiction of the High Court. However, just at the end of the lecture, we'll be doing a we'll be doing an exercise. Now the endeavor will be to involve all of you in these practical aspects of litigation. Now, as law students, how you can practically get involved, in the in various aspects of writ jurisdiction is by means of being inquisitive, as to what all wrong is happening around you. So I would suggest that all of you pen down certain activities that you think, in your opinion, are happening in an illegal manner. Now, how to find out such activities? Anything, anything that is hampering, the liberty of the people around you, including you, hampering the life and liberty of the people around you, including you, that you can very well identify as something that is an illegality, right? So, this is one thing which you should do. Pen down everything. Maybe there's something, uh, maybe you'll see that uh, the municipality people, they are, um breaking somebody's house, they are doing some sort of destruction to the common buildings and everything. But then that is the point when you'll start writing it down and you'll start questioning yourself whether is it legal, whether is it illegal, what is it about. So that inquisitiveness will educate you with regards to the practical aspects of law. You can also note down my email ID that will be provided to you by the moderators. And in the alternative, you can also find me on LinkedIn, and you can also share such kind of activities that you are doing with regards to finding out as to what all illegal activities are happening around you. However, the writ jurisdiction, you need to understand, it's basically a private right. It's not a public right. Only the affected person can very well approach the High Court. Only the affected person can very well approach the High Court. So there are two things you need to show while you are filing a writ in the High Court. Your locus, how are you affected, how are you aggrieved, and secondly, you need to also see as to you need to also show the honorable court as to how or in what manner is there illegality with regards to the order that you are challenging or the inaction of the state that you are challenging. Now the second part of my topic is PIL. Now, who coined the term PIL, when was it, when did it start and everything, that you can very well, that you will very well taught in your coming years. That is all theory. The practical aspect about PIL is that it's a public interest litigation. As the very name suggests, it is with regards to the interest of the public. There are many judgments which say that private interest litigation cannot be treated as a public interest litigation, right? So, but then what is a public interest litigation? What is it practically? What actually is a public interest litigation? And mind it, there is an exercise for you with regards to this as well, which will be very interesting. That I'll tell you at the end of the lecture. Now, what is a public interest litigation? See, any action of the state, any action of the state that is affecting some segments of the public at large, or some particular sects of the society. अब आप मान लीजिए कि फॉर एग्जाम्पल से if there's an order of the state government that no, the factories will now be established, the various factories will now be established inside the cities and not outside cities, right? So this is something that is, I mean, I hope you have you know about the pros and cons, largely the cons of, I mean, a factory outlet, a factory establishment. I mean, there is a lot of pollution. Things get burnt up, things get broken, things get beaten up, and there's a lot of pollution. Lot of polluted gases get emitted. Lot of solid waste, liquid waste gets emitted from a factory outlet. So primarily, this is an action. This is an order of the state government, which is hampering the or which will hamper the public at large. So a public spirited person or an organization or an individual that is affected by such an action can very well file a public interest litigation. Okay, so that is how it is. Now, when I say that, now, I mean, when it comes to the practical aspect, if you see, I mean, there are hundreds and hundreds of PILs that are filed before the High Court, before Supreme Court, before various, I mean, various courts. But the end result is that only 10 to 15% of those PILs, they get successful. Now, what is the reason? The reason is because you cannot merely be a public spirited person and just file a case. You need to have some knowledge of law, right? So most of these people who file PIL, they are mostly NGOs, non-governmental organizations, they're mostly social activists, and mostly, now this is the most important part, mostly these PILs are malicious. These PILs are malicious. Now when I say malicious, it means that there is some innate latent interest in concerned person who's filing the PIL. So what happens then? Then various high courts, the Supreme Court, wherever this PIL is filed, they dismiss it with humongous costs towards the person that have filed said PIL. So this is one thing. Now, what you can do with regards to public interest litigation, I mean, you will be happy to know two things. You may not be individually affected particularly for filing a PIL. You will find various case laws which say against it. You will find various law books which say against what I'm saying. But what I'm saying right now to you is correct. You may not be privately affected by an action of the state to file a PIL. You may not be... Hello? Was there a query? You may not even be a citizen of that particular place where the cause of action with regards to PIL is arising. But you can still file that PIL, provided that is in public interest. Now, the interesting aspect that can be an interesting exercise that can be carried out by all of you is that pen down these things, pen down the activities, actions of the state, actions of the various statutory bodies that you find in derogation with the rights of the public. For example, if you see that there's a lot of pollution that is happening unnecessarily and the state is not doing anything with regards to it, you just pen it down, research a bit, and then you may email it to me if you want, or you may contact me on LinkedIn and then share it with me. All of you may do it, and whichever of such notings I find relevant, both of us can then file a joint PIL with regards to it. So now this exercise will make you think out of the box. I remember when I was a law student, I remember when I had gone to take lectures to various places all over the country to take lectures. I mean, I used to find it as a very mechanical exercise. You know, like a 10 to 5 job. Boring. But then, the thing is now, when I try to think out of the box, I get ideas with regards to it. And that is what makes your interest in law. Read about PIL, give 15-20 minutes of your reading for 2-3 days to the aspect of public interest litigation. What are its basics and all? And then you go around. You move. When you go for a walk, when you go for some activity, think like a lawyer, 24/7. Then you will get ideas. I mean, I'm sure all of you must be knowing about Mr. M.C. Mehta. Mr. M.C. Mehta versus Unit of India. So he has become an environmentalist only because of his inquisitiveness and because of his unparalleled efforts to the environment. I have got a chance to meet him in person. And he's a very humble person. He's always open to ideas. In a 5-minute conversation which I had with Mr. M.C. Mehta, who is considered as the father of the present day PIL movement, in the 5-minute conversation which I had with Mr. M.C. Mehta, he was trying his best to get ideas out of me so that he may file another case so as to help the people of our country, the environment, and that is it. So these kind of exercise you need to do. But always keep this in mind. I mean, I have defended a lot of PILs. I being on the opposite side. There were a lot of private interest litigation that were filed. And I was on the opposite side. So my arguments were to dismiss such frivolous PILs. And they have been dismissed with humongous costs. No, PILs should not be malicious. There should not be an innate interest attached to it. It should not be like ये PIL allow हो जाए तो मुझे ये फायदा होगा. If the court comes to know about it, then definitely cost will be imposed upon the concerned litigant. Nevertheless, it was really very nice talking to all of you, and I hope for an interactive session with all of you. You are free to connect with me on LinkedIn. You are free to connect with me on my email ID. My email ID is tane_hazari@yahoo.com. For any ideas, for anything, or for any help which you want with regards to your career. Thank you so much, all of you.
Thank you so much, sir. So it was really valuable information that you have given us, and it was really fruitful for this session. And thank you so much, sir, for sharing all your thoughts regarding the topic.
I request for each and every participant to wait for 5 minutes, wait for 2 to 3 minutes so that the next speaker can be able to join us for the book launch. We request each and every participant to wait for the ID of Tane Hazari, sir. We will be delivering you the ID within 5 to 10 minutes. As soon as he will be giving us, we will be delivering you in the meet itself. Wait for a few minutes. As one of your member has already given the email ID of Tane Hazari in the group chat only, kindly refer to it and if possible do share among your peers.
before moving on to the book launch, I'd like to give a small talk regarding what is welfare state. So, you guys, anyone know what is like mean welfare state? You can type in the chat as well. Okay, no worries. So basically, we'll just talk about it till Sir comes. So, oh, you can't hear me? Can everyone hear me? Okay, great. Yeah, welfare state is a state which is involved in social welfare activities. Very good, very good. So, very good, Asha. So, I like that answer. So basically, a welfare state is a state which is like committed to providing a basic economic security for its citizens, by protecting from the market risks and all the associated with old age, accidents, sickness, unemployment, etc. So these are called welfare states. So do you think India is a welfare state? Okay, great. So why do you think India is a welfare state? Is there any programs which India brought in? Yes, very good, excellent. So, so we have talked a bit about welfare state. Now let's move on to what is um, the book launch regarding this. So basically, the book launch is all about the role of nation state in global perspective, which is written by the author for this book is Amit Kumar Sir, who is the assistant professor of law, Indore Institute of Law. So basically, the role of nation state in globalization is a complex one, and in part due to the varying definitions and shifting concepts of globalization. So while it has been defined in many ways, globalization is generally recognized as a fading or complex disappearance of economic, social, and cultural borders between the nation states. So we are actually talking about the book. So uh, also, some scholars have theorized that nation states, which are inherently divided by the physical and economic boundaries, will be less relevant in the globalized world. So, while increasingly reduced barriers regarding international commerce and the communications are sometimes seen as potential threat to nation states, and these trends have existed throughout history. Air and sea transportation have made the same day travel to other continents possible and greatly expanded trade among the countries, not about the sovereignty of the individual nations. So instead of globalization, it is a force that changed the way the nation states deal with another country, and also particularly the area of international commerce. So this is all about the summary, and I would like to call Amit Kumar sir to share thoughts on this book.
Thank you, Aditi. Good evening, everybody. So, as Aditi has already introduced about me, but still I would like to introduce a little bit. So, my name is Amit Kumar. I hail from Begusarai district of Bihar. I have done my graduation in law from Rajiv Gandhi National University of Law and LLM from Jagannath University. Presently, I am pursuing PhD from NIMS Jaipur, and also I am pursuing MBA in distance education mode from Symbiosis International University. So presently I am associated with Indore Institute of Law as an assistant professor, and I'm also the head of skill development cell of my college and a member of election commission of Indore Institute of Law and Rubaru Club of Indore Institute of Law, which basically works for inculcating constitutional values. Now, coming to this topic, why I have chosen to write a book on this topic. So, the sole purpose is since I am pursuing the PhD on this same topic, role of nation state in globalized order. So, when Honorable Prime Minister of India, when he asked for feedback for his Man Ki Baat program, so I was thinking that why China has progressed so much in last 70 years. So, all my dear members, as you are aware that China got independence after India, or we can say that both India and China got independence at the same time. But China has progressed so much, and we are also progressing, but then it will take some time to catch China. Now, if you see the international order, the bipolar world is between USA and China. And at one point of time uh, in history, we have already learned that at one point of time, China and India dominated the world trade. And India was always known for this shipbuilding, and the contribution of India in world trade was immense. So when I tried finding out the reason, then I came to know that internally also and also at global level, India was very conservative. There is there is I personally feel that being conservative in its international standing is I don't think there is any problem because India got independence from UK, and India was afraid that if either India takes side of either of the countries like USA or USSR, then it will be very difficult for India to progress. And because of this reason only, joined or India headed non-alignment movement. So a neutral set of countries came together in international order. So while researching on this topic, internally I came to know about that since we were following license Raj, as we were following license Raj, it was very difficult for a private venture to take license from the government of India and invest in any part of the country. Externally also we came to know that as India was following non-alignment movement, the participation of international stakeholders in Indian trade was very limited. Obviously because of the legacy that we inherited from the Britishers, the freedom struggle that we have gone through. So because of all these reasons, India followed this conservative approach. But then in 1990s, as you know that we were following balance of payment crisis. And because of this balance of payment crisis, the then Prime Minister of India and also Finance Minister of India, they liberalized the economy. And and from then onwards, we are following the policy of liberalization, globalization, and privatization, the LPG policy. So, why this policy was adopted by the government of India? So, the first reason was this balance of payment crisis, but then it was also felt that the conservative stance of government of India, it is not that fruitful. China, in comparison to China, India, India follows democracy. In China, it is communism, the dominance of one party system in China. But they are more liberalized than India when it comes to this international trade. So even a country like China is not following state ownership, which is basically communism. So from that lesson, India has decided to go with this mixed economy model and also this LPG model of liberalization, privatization, and globalization. So the things that I have inculcated in my book that now time has come to liberalize Indian economy more And I have already given this suggestion to Government of India. I have requested that other than judiciary and police, we I do personally, I find there is no logic why there why there is governance, why there is this government interference in any activity. Obviously we need government support in judiciary and also in police. But then in all other activities, the role of Indian government is welfare. As you know that India is following welfare model of governance. And also only when there is this mismatch between this privatization and welfare mechanism, then only should government interfere, which is also termed as regulatory approach. So in this book, because of time constant, I don't think that I have the liberty to explain much. But if I were given this opportunity, then I would like to end this webinar by saying that the role of Indian government should only be this regulatory and welfare mechanism should be followed. But now time has come to give more and more space to this private organization, private enterprises. Now, Government of India is also following the same. As the Honorable Prime Minister, he promised in his last Independence Day approach that he will be privatizing this government oriented banks and also insurance companies. And I personally feel that government is moving in the right direction. So thank you, Aditi. Now I hand over this mic to you.
Thank you so much, sir, to really tell us, really give a glimpse on the topic, that role of national state in globalized order, and I shift my platform to Shweta, who will be giving vote of thanks to you. Over to you, Shweta.
Thank you, Aditi.
Thank you so much, sir.
Thank you so much, sir, for all the valuable comments you have given. And this book is, when you talk about the summary of this book, it is really awesome. So thank you so much, sir, for coming and joining us and talking about this book. Thank you so much, sir.
Thank you, Aditi. Thank you, Aditi. Thank you, Shweta.
Thank you, sir. So now, for the next lecture, we have Rahul Tiwari, sir. To give a small introduction about Rahul Tiwari, sir, he is the assistant professor at Indore Institute of Law, who is specializing in cybercrime and economic offences, and the former associate at litigation firm Lamba and Lamba Gurugram, and the founder Illness Associate of Gurugram. So, welcome, sir, to this bootcamp. We shall wait for a few more minutes for sir to come, and then he shall start off with the lecture. So after Rahul Tiwari's sir's speech, we have one more book launch which is coming up. So after that, we have another lecture which is given by Dianshu Bhatt sir. So we shall wait for all of the speakers to come and join us.
In the Legal World is presenting with litigation codes.
We request all the participants to wait for a few minutes so that the advocate Rahul Tiwari sir can join us as soon as possible.
Hence, this litigation course will help you to understand the risks, alternatives, and the realities of the major stages of litigation. By By working through case studies, you will understand litigation comprehensively. Moreover, this course will help one flourish and attain an in-depth legal knowledge related to litigation. You will also explore essential technical information and have the opportunity to put that into practice through skill-based exercises. This course offers a solid grounding in the litigation course, additional reading and discussion on amendments to laws and recent judgments, complete coverage of laws including CIPC and other special statutes, stimulation exercises based on recent developments and action case laws, anecdotal discussion by our industrial academia panel about their experience in handling civil cases. Online classes will be on weekend evening for 2 hours. Recordings for lectures will be provided. Certificate of participation to everyone on completion of course. Certificate of merit on 60% attendance and 50% assignment submission. Confirm internship for meritorious students under senior advocate and litigation firms. In case a landmark judgment is passed by Supreme Court that shall be discussed apart from the syllabus. The idea of this course is to equip students with fundamentals of criminal, civil, and constitutional laws. This course is a combination of practical execution and interpretation of various statutes of law. So, what are you waiting for? Grab this opportunity. Interlegal World is presenting with litigation course. Litigation allows people to settle disputes that they have been unable to do on their own. Hence, this litigation course will help you to understand the risks, alternatives, and the realities of the major stages of litigation. By working through case studies, you will understand litigation comprehensively. Moreover, this course will help one flourish and attain an in-depth legal knowledge related to litigation. One will also explore essential technical information and have the opportunity to put that into practice through skill-based exercises. This course offers a solid grounding in the litigation course, additional reading and discussion on amendments to laws and recent judgments, complete coverage of laws including CIPC and other special statutes, stimulation exercises based on recent developments and action case laws, anecdotal discussion by our industrial academia panel about their experience in handling civil cases. Online classes will be on weekend evening for 2 hours. Recordings for lectures will be provided. Certificate of participation to everyone on completion of course. Certificate of merit on 60% attendance and 50% assignment submission. Confirm internship for meritorious students under senior advocate and litigation firms. In case a landmark judgment is passed by Supreme Court that shall be discussed apart from the syllabus. The idea. Welcome, sir. So, I like to give an introduction again for Rahul Tiwari, sir. So, Rahul Tiwari, sir, is an assistant professor at Indore Institute of Law and specializing in cybercrime and economic offences, and the former associate at litigation firm Lamba and Lamba, Gurugram, and the founder of LNS Associate Gurugram. So, sir, welcome to this last day of bootcamp. And sir, you'll be for this session, sir will be covering the concept of the Order 37 of CPC, the concept of court fee, understanding jurisdictions of civil cases. So thank you, sir, for coming to this bootcamp. And now I'd like to handle this session to Rahul Tiwari, sir. Sir,
Should I start? Am I audible now to everyone? Okay, fine, cool. So just day before yesterday, we had completed the art of direct reading, and we did completed. Please open your parent. Yes, I know. And if you have it, very good. So, today we are going to do about the bail provision for the non-bailable offences. Okay, so let's do a quick recap. If I remember, what did I told you day before yesterday? Share screen of the Bear Act. Just wait, because I'm not sharing my module as of now, because the module shall be shared with the students, because that's where during the course, because in that I'll share my own handwritten notes also. So it will be good if you just open the Bear Act and you keep it in front of you. So I'll request that will be more appropriate. Okay. So let's do a quick recap what we did yesterday. It was we have four type of courts: judicial magistrate first class, and then chief judicial magistrate. Both these courts are called magistrate courts. Above them, we have sessions court, which was ADJ court, and district and session judge court. Till CGM, the power to punish a person is up to how many years? It is for the power is up to 7 years, and in the sessions court the person has unlimited, means the person can give death penalty also, means there is no upper capping in the nature of the punishment. Now let's do a quick recap of section 436 again, and what I was telling you about the art of direct reading. So again, if we can see this, in what cases the bail can be taken. Provision 1, what does it say? When any person other than a person accused of a non-bailable offense. Read April here. It means a person is accused of committing a bailable offense. According to this section, means any person other than, just focus on these phrases, other than a person accused of नॉन बेलेबल ऑफेंस. तो वो कौन सा इंसान हो गया जिसने बेलेबल ऑफेंस करा हुआ है, तो उसमें आप किस कौन से सेक्शन में आप बेल लेंगे? सेक्शन 436 के अंदर बेल लेंगे. ओके, इज अरेस्टेड, फर्स्ट एसेंशियल क्राइटेरिया, सेकंड एसेंशियल क्राइटेरिया, अरेस्टेड or detained without a warrant. Mind you, if you have what does this section also wants to say is that if a person has committed a bailable offense and is arrested with a warrant, then it is valid. But if a person is arrested without a warrant by an officer in charge of a police station, or appears or is brought before a court and is prepared at any time while in custody of such person at any stage of the proceeding, at any stage, please, if you have the Bear Act, underline with your pencil, at any stage of the proceedings before such court to give bail such person. Remember I told you day before yesterday that in the first line it is any person, then that any person specifically becomes such person by the when you come up to the fourth line, such person, mark it, shall be released on bail. Means the court is going to give such person a bail. And now another recap, like suppose what is a bailable offense and what is a non-bailable offense. Bailable offense are those where you can get the bail from the police station itself. And non-bailable offence are those where you have to apply for the bail from the magistrate, where the police cannot give you bail directly. Okay. Now, when we read the Bail Act, then comes the proviso part. Means proviso is what? Exceptional cases. Means this will happen provided if this is the case, then it will not happen. Now I'll give you an example. Proviso, such officer, if he, I gave you an assignment, I guess only two person, let me give the name of those person who have submitted the assignment. See, such person who are diligent enough will be always be rewarded. Okay. So the assignment has been submitted by Shashta Vashim and Lavkesh Kaur, and both of them has given the right answer. And I'm really proud of you that you have taken these assignments seriously, and you have enjoyed these assignments. Okay, because these assignments were such that usually in law schools they are missed out. Okay, while teaching, or these are something which are very basic in nature, which even the students try to miss out. But with the course of time, you understand that although it was very basics, but it was very important also. Now the proviso says may and shall. Means, wait, just give me 1 minute. I guess something is in my eyes. Just give me 1 minute. Thank you so much for waiting. Okay, I'm really sorry. Now, usually you will see that either you have a may provision or you have a shall provision. Okay, but and this proviso, and always remember, bail is your right, but it is always on the discretion of the court. How? I'll come into that in within 10 minutes, within 5 minutes. Okay. Now, here, may and shall both are used. So please make a small note in your Bail Act. Just encircle the may, and above that write with or without bond. And shall means the person shall be released. Shall means the court is going to release that person, but may means the court, when the bail is taken, what actually happens that you have to submit a surety, okay, and you have to sign a bond. Means a person has to take a surety of you that okay, I'm the you can you can bring two surety in the court, that or one surety. It depends on how many surety the court wants, and you give those person gives a surety, okay, that he's a diligent person, he will not run away, okay, and he will not tamper with the Urvashi, please I cannot entertain as of now directly, okay. No, I'm on the first paragraph itself, first proviso, okay. This is the explanation part, you are getting confused. So it means, okay, let's make a rule. If I'm teaching, nobody questions that time, because what happens that it breaks the flow. Okay, because ultimately I would have come to that point, right? So, you have to be with me till that time. Now, see, may and shall is used because may, no problem, Rashid. हम ये चैट सेक्शन में डिलीट कर देते हैं, वो बार बार मैसेज पॉप करता रहता है. Okay, चलो. So what actually happens is that shall provision, first of all, it means the court is going to give the person bail. Shall. May means first surety you have understood, someone else gives you. Bond means you sign a bond, like it can be of 10,000 rupees, 5,000, 50,000, that in case I jump the bail, or that in case I break the conditions of the bail, I shall give this much amount of money as a fine to the court. So, explanation part, in the bail at first you have the proviso and then explanation. Explanation means it further explains the offense. Okay, or it further not offense. If it is if you're reading IPC, then it explains the offense, and if you are reading any other law, it further explains that section. Because when we will read section 138 of Negotiable Instrument Act, there I teach you a very nice, very amazing rule of 30, 15, 30. Okay, and that is something is going to amaze you a lot. So explanation part means it further elaborates that particular section. So may part is elaborated that if a person feels that, if the court feels that this person is very poor, and the court is convinced that this person is not able to furnish any bond, is that poor, then the court can release such person either on a bond or without a bond. So this was the gist of section 436 to you. Now, please come to section 437, and after that we will move to Negotiable Instrument Act, and then how do we, whether we can file a civil case and a criminal case together, and Order 37. Okay, this small part of CPC I'll cover. Okay, now please open section 437 of the CRPC. Now, what does it say? Section 437, I'm going to read it out for you, and see, that's why I told you not to read the book at first instance day before yesterday, and today I'm going to prove why I used to always say such things. Okay, now 437. Okay, when bail may be taken in case of non-bailable offense, means the offense's first criteria is the offense is non-bailable in nature. Now, clause 1, what does it say? When any person, underline any person, accused of, first part, or suspected of, or commission of, suspected of, commission of any non-bailable offense is arrested or detained without warrant by an officer in charge of a police station, or appears is brought to the court other than, just wait up till here. So section 437 talks about what? What are the essential criteria? That first of all, the person is arrested and the person has committed, the first of all, the person is arrested, and second, the person has committed a non-bailable offense. These two are essential criteria. But non-bailable offense में तो कुछ भी हो सकता है. It can be an offense where the punishment is 5 years, and it can be an offense where the punishment is 20 life imprisonment also, right? So in which case you are going to file the bail application? That becomes important. And day before yesterday, I did told you that all the cases, bail cases, where the such cases, first where the offense is non-bailable in nature, first it goes to the court of CGM. Always remember, even if it's a rape case, in rape case the punishment is how much? Minimum now 10 years. Okay, before I'll give you an example. Before earlier, I can't remember what was the punishment, but after the Justice Verma committee, for your your knowledge, when the Nirbhaya, unfortunate case of Nirbhaya happened in our country, and then Justice Verma committee was set up. Justice Verma committee gave a very important recommendation. First of all, they removed the death penalty, but they didn't say that they did recommended that the rape for the offense of rape, the death penalty shouldn't be there first, and it said that the minimum punishment should be 7 years and maximum should be of life in prison. But again, if you go in the history, around the time of 2016 and 17, there were a lots of cases of gang rape which took place in India. Okay, and in those gang rapes, most of the victims were minor girls. Okay, minor girls, and that too, in majority of the cases, the age of such rape victim was less than 10 years or 14 years. Okay, so POXO used to come into the picture, but the offense was taking so much that again it was decided by the lawmaker that we need to make the law more stringent. So what happened, that although CRPC was also amended, but in IPC section 376 was amended, and it was new clauses were added, and first amendment was that took place was that minimum punishment was made 10 years first. Second, it also introduced the concept of death penalty for the offense of rape, provided if a person commits a rape or a gang rape of a woman, or sorry, not a woman, of a girl whose age is less than 12 years. Then in that case, if it comes under the criteria of rarest of rare offense, can anyone give me a suggest that this part, rarest of rare offense, in which landmark judgment it was first discussed? Anyone?
What is State of Punjab? Bachchan Singh.
Asghar, can you please do one thing? Write it down in the chat box. I can't hear you.
Sir, Bachchan Singh.
Bachchan Singh, yes. Right answer. Very good, Asghar, Asghar Ali. So
Yes, sir. Yes.
that was the, and I request everyone that do please connect with me on LinkedIn. Okay, it's an amazing platform, and I love if every one of you connects with me on LinkedIn. Okay, so it was Bachchan Singh's judgment which gave us the concept. Yes, no, not Union of India. I think it was State of Punjab. Check it again. Yeah, and 1980 Supreme Court. So what actually happened? No problem, bache. It's okay. First of all, it's fine. Committing mistakes, it's okay. It's not a sin. You guys are students and you are bound to make mistakes. And me being your faculty is going to correct you. Okay? So first of all, a great, I would say, round of applause for Srishti. Mishra, at least she tried. And this is, I'm telling for everyone. Please do try. Try करिए, गलती होगा कोई बात, but try करिए. Okay? चलिए. And it's okay. At your age, I was not even this much of serious that, I was not that kind of person that who's going to ruin his Sunday evening to read what? Criminal law? No. I was the kind of person that who would have preferred in his college life, would have preferred to enjoy Sunday evening with either with girlfriend or with her friends and have a nice time. Means doing anything except studying. So huge round of applause to all of you who are taking out time for studies. Okay, so trust me, you all of you, it shows how serious you are for your life. Okay, so thank you. Now you have understood that if it is a no problem, Srishti, it's fine. Now you know now. Suppose in CLAT exam, if in CLAT exam, if this question comes up, now Srishti, I hope I can expect in ILET or in CLAT exam, you are going to take the right answer now. Okay. Now, suspected of, you have understood that if it is a non-bailable offense, the it is a non-bailable offense, the bail can be given, but in which court? Now, in section 437, read the last line. Is brought before the court, now start underlining, other than the High Court or Court of Session, comma, he may be released on bail. And didn't I told you just 5 minutes ago that bail is the right of the person, but granting bail is always on the discretion of the court, whether to grant the bail or not. Okay, whether to grant the bail or not, it is always on the discretion of the court. So, here it is written that other than High Court or Court of Session, तो इसके अलावा कौन सा कोर्ट बच गया? कोर्ट ऑफ मैजिस्ट्रेट. कोर्ट ऑफ मैजिस्ट्रेट में कौन सा कोर्ट? CJM. Why? Because 3 साल से कम की जो सजा जो ऑफेंस होते हैं वो एक्सेप्ट few offenses like domestic violence case of section 498A and few others, all the cases are bailable in nature. So non-bailable offense and court other than High Court or Court of Session, तो सिर्फ एक कोर्ट बच रहा है section 437 में, that is Court of Magistrate. ओके, कोर्ट ऑफ मैजिस्ट्रेट में भी कौन सा? आपका CJM कोर्ट, या फिर जब आप इंटर्नशिप करने जाते हो तो आप देखते होगे कि ACJM एडिशनल चीफ जुडिशियल मैजिस्ट्रेट जो जस्ट CJM से छोटा पोस्ट होता है, जस्ट इमीडिएटली, एंड नेक्स्ट प्रमोशन ही बिकम्स CJM. ओके, सो नाउ आई होप यू अंडरस्टैंड that this criteria means if there is an offense, now एक छोटा सा नोट बना लो, if there is an offense committed where the punishment is more than 3 years but less than 7 years, तो कौन से कोर्ट में बेल एप्लीकेशन जाएगा? CJM कोर्ट में. कौन सा सेक्शन अप्लाई, which section will be applied? section 437. so ये चीज क्लियर हो गई. नाउ दूसरी चीज और क्लियर कर लीजिए कि जब बेल एप्लीकेशन आपकी फाइल होती है और वहां पे पनिशमेंट 7 साल से ज्यादा है, तब कौन सा सेक्शन अप्लाई होगा? स्ट्रेट अवे सेक्शन 439. सो सेक्शन 439 क्यों वहां पे स्ट्रेट अवे लिखा है? द पावर टू ग्रांट बेल बाय हाई कोर्ट और कोर्ट ऑफ सेशन. ओके, तो दिस पार्ट यू हैव टू अंडरस्टैंड दैट अगर बेल अप्लाई भी होना है तो कौन से सेक्शन में होना है और कौन से कोर्ट का होना है, ये जानना ज्यादा जरूरी होता है. बट व्हाट विल हैपन इफ यू रीड द बुक? Okay, if the High Court or Court of Session, you will not even bother to know which court then. The High Court or Court of Session होगा कोई court can grant the bail under section 437 under these criteria. Okay, this happens when you read the book straight away instead of touching the parent. Now I'll give you another example. What is it is written? एक word पे अब आप नजर रखिए. He may be released on bail, comma, but such person, first part, such person shall, underline shall not be released shall not be released if there appears a reasonable ground for believing that he has been guilty of an offense punishable with death or imprisonment of life. Means if he has उस पर्सन को नहीं छोड़ा जाएगा बेल पे सेक्शन 437 में, जिसमें कोर्ट को लगता है कि उसने कोई ऐसा ऑफेंस किया है जिसमें लाइफ इम्प्रिजनमेंट मिल सकती है या डेथ पेनल्टी मिल सकती है. उस केस में वो बेल एप्लीकेशन कहाँ फाइल करेगा? आपको लग रहा होगा कि नहीं, जब 439 में स्ट्रेट अवे बोला गया है, you know, when it is straight away written that power to grant bail by High Court or Court of Session, then why I'm consistently telling you that the case first goes to the Court of CJM? Again, just give me 5 minutes, I'll prove that. Because in practice you'll see that thing only. See what will happen. So उस first case, उस केस में bail नहीं मिलेगी. Second, such person shall not be released on the bail if the offence is cognizable in nature. Can anyone tell me again, Asghar, what is cognizable offence?
Sir, those offences which are heinous in nature, and for basically we must restrict on the schedule first of the CRPC. In schedule first, the offences are defined as what offences are cognizable and what offences are not cognizable. But
and
simply,
how about taking the warrant before arresting?
Yes, sir.
Means in cognizable offense, the person can be arrested without warrant.
Yes, sir. Without warrant.
Yes. Now, such person shall, again underline this part, shall not be released if if the offense is cognizable in nature and he has been previously convicted of an offense punishable with either death, imprisonment of life, or imprisonment for 7 years or more, or had been previously convicted for 2 or more occasions of a cognizable offense where the punishment for 3 years or more but less than 7 years. So in such cases the court shall not give the bail, okay, under section 437. But now read the proviso. But see, the proviso part is important, because if you are appearing for your judiciary exam, especially in your mains exam, you will not write the answers. See, what actually happens when you write your semester exams? What happens? First, you make you draw a line on both the sides of the paper, okay, so that you have to write less amount of information on the page. You'll make a line on left side, and then you make a line on right side, so this much of space is left, okay. Then you write a 1 page of synopsis, okay, because synopsis के भी 12 मार्क क्वेश्चन में 1 मार्क होते हैं ना लॉन्ग आंसर्स में, okay. Then you will make a synopsis, and then you will first explain what is bail, which courts explains the bail. Then you will go on to give the elaborated definition, okay, and then what are the conditions for the bail, when bail can be cancelled, all the stories. Then you will write 2-3 landmark judgments, and when you will see that, okay, I have filled 10 pages, okay, then you will stop, and then you will switch to the second answer, okay. यही होता है, because and everyone does that. Everyone has done the same thing, okay, because 12 mark question, we know we have to write at least 12 to 14 pages. इससे कम लिखेंगे तो कम मार्क्स आएंगे सेमेस्टर एग्जाम्स में. It's a very sad state of affairs, which I strongly feel that it should be avoided, because when you go to the judicial service examination, you know, there is such a huge paradigm shift that for 12 mark question you are writing 12 pages in your semester exams, but when you will write a judicial service examination and suppose a 15 mark question comes up, okay, what will happen in that case? In 15 marker you have to write only 150 words. 20 marks question, 200 words. 200 words means hardly 1 page or 2 page at max. So how do you write? You explain and you go into the very basic part, and you give the basic definition that under section 437 clause 1, the explanation is this. This code gives the bail, and the proviso of section 437 clause 1 says this thing. The second proviso says this thing. The third proviso says this. Fourth proviso says this. Okay. So this is the huge difference which you have to ensure, and I hope all of you have at least who has given at least 1 semester or 2 semester exams will agree with me, right? Like 12 marks question means 12 pages. Please give thumbs up in the chat box whether I'm saying the right thing or not. 12 markers, how many pages you have to fill in your semester examination? See, this is the reality. Now, proviso. Proviso means, first proviso says that the court again may provision. The court may direct a person referred to in clause 1 or clause 2. Clause 1 says what? If he has committed an offense where the punishment is death penalty or imprisonment of life. And clause 2 means that if the person is previously convicted for death penalty, Urvashi, in your judicial service examination, the correct explanation of wherever provision in a simple language, your research part, and good case laws. These 3 things are important. These 3, and how you manage to give all the information in a correct and precise form, it Is it true or false? The CGM can give bail. The CGM can give bail even in the rape or murder cases. How? Again, let me rephrase it everything for you. Section 437, it says the offense, if the person is accused of an offense, accused of an offense of a non-bailable case, the case goes to the CGM court. Why? Because वहाँ पे लिखा हुआ है court other than high court और court of session. But किस cases में court सजा नहीं देगा? First part है क्लॉज 1 का फर्स्ट पार्ट कहता है कि अगर ऑफेंस जिसमें जहां पनिशमेंट दी है, जहां पे पनिशमेंट या तो डेथ पेनल्टी है या लाइफ इम्प्रिजनमेंट है, सेकंड पार्ट या फिर प्रीवियसली कन्विक्टेड फॉर लाइफ इम्प्रिजनमेंट और 10 इयर्स और कन्विक्टेड ट्वाइस फॉर एन ऑफेंस ऑफ 3 years, more than 3 years and less than 7 years. ठीक है, इन तीनों केसेस, इन 3-4 केसेस में अगर ऑफेंस हुआ है तब कोर्ट बेल नहीं देगा. क्यों? तब वो चला जाता है सेशंस कोर्ट का मामला है. बट प्रोवाइजो 1 सेज, बट उसमें भी एक एक्सेप्शन है. सीजीएम ऑल्दो ये सब केसेस में बेल नहीं दे सकता, बट एक एक्सेप्शन है कि वो एक्सेप्शन क्या है प्रोवाइजो 1 में कि द कोर्ट में डायरेक्ट a person प्लीज मार्क पर्सन लिखा है, मैन और वुमेन नहीं लिखा है. This is most important to be noted. Person लिखा है, man women नहीं लिखा है. So it is gender neutral. तो CGM एक लड़के हो चाहे लड़की हो बेल दे सकता है. वहाँ क्यों person लिखा है? आप मेरे को बता दीजिए person का मतलब क्या सिर्फ लड़का होता है या लड़की होती है? Person तो कोई भी हो सकता है. And this is how you read and understand the bill. आप समझ गए? क्योंकि यहाँ पे person लिखा है, that such person is under 16 years of age. अगर 16 साल से कम का व्यक्ति है तो उसको हीनियस ऑफेंसेस में भी CGM बेल दे सकता है, या फिर वो पर्सन एक औरत हो तब बेल दे सकता है, या फिर द पर्सन सिक हो, बीमार हो, या फिर इन्फॉर्म हो, अगर उसको भी मेंटल इन्फॉर्मिटी है, किसी चीज की परेशानी है, किसी चीज की बीमारी है, तो उस इन चारों केसेस में यस नाउ यस ओके, इन चारों केसेस में सीजीएम मर्डर और रेप केसेस में भी बेल दे सकता है. अब मैंने आपको एक चीज और बताई थी जो एक प्रैक्टिकल एस्पेक्ट है. मैंने आपको डे बिफोर यस्टरडे आई टोल्ड यू दैट व्हाटएवर यू रीड इन सीआरपीसी कम्स इन द कोर्ट. And it's a very popular opinion which is made by our seniors also that no, whatever we are reading in the code does not apply to the code. No. Why? They'll say, you have read this thing in the merit, but it's not applied in the code. Sorry. I just told you what? All the cases goes to the which code? CGM code. And then it is transferred. First, suppose now I'm giving a practical aspect. What actually happened? If it is a murder case. Day before yesterday I told you all the magistrate comes under CGM, means all the police stations are under the control of CGM. Murder case takes place, the case goes to the magistrate court first, which is the CGM. Magistrate means CGM, not JMFC. Why? Because JMFC does not have the jurisdiction to give the punishment for more than 3 years. उससे ज़्यादा है डायरेक्ट स्ट्रेट अवे एक ही मैजिस्ट्रेट फिर बचा CGM के कोर्ट में केस जाएगा. क्यों? उसके अंडर सारे आ रहे हैं. एंड देन द CGM will see that okay, can I grant the bail? He will see that okay, offense is what? The punishment is less than 7 years. The CGM will look into the technical aspects that can the CGM gives bail or not. If the CGM wants to give bail, CGM will give bail. If the CGM does not want to give bail, the CGM will reject the bail. But second condition, if the CGM sees that okay, the punishment is more than 7 years, then the CGM will not give the case except for the 4 cases if it falls under the criteria of proviso 1 of section 437 clause 1. अगर सेक्शन 437 क्लॉज 1 के प्रोवाइजो में आ रहा है तब भी सीजीएम बेल देगा. याद रखिए इस चीज को. अदरवाइज वो उस कोई आपसे पूछेगा तो क्या बोलोगे कहीं पे कि राहुल सर ने बताया था? नहीं, सेक्शन 209 ऑफ सीआरपीसी, पास करने की पावर, adjourn करने की पावर. If some recently this तारीख पे तारीख phrase was used by Dhananjay Chandrachud. And please guys, one more thing, download live law. Download live law, take annual subscription. It will hardly cost you like 30 to 40 rupees. And if you have if this bootcamp would have conducted in the month of August, I would have told you to just go for the Independence Day offer. There was a huge discount of 50%. And I also took the advantage of such a discount, and in just 1900 bucks I took 2 years annual subscription. And please read live law every day. It is the best and the most authentic platform for any legal news update, and also for your legal research, also the quick legal research. Okay, so always remember this part. So this is one thing. Now I hope now I have made you understood now that whatever I have saying, it is always backed by the provision mentioned in section in the sections of and now we are running out of time because this bail part actually take 2 to 3 hours to teach you. So let me see if there is some more important thing. So now you have understood now that कौन से कोर्ट में केस फाइल करना है बेल का, कब बेल कोर्ट बेल दे सकता है, और हमेशा रिमेंबर वन थिंग, इट इज ऑलवेज ऑन द डिस्क्रिशन ऑफ द कोर्ट. वकालतनामा of all the lawyers is the same. Yes, it is almost in the what is wakalatnama, that the advocate gives the written statement to the court that yes, this person, the complainant or the defendant has read section 375 fourthly clause of section 60 fourthly clause, where the husband not fourthly clause, I mean section 375, where the husband is exempted from the offense of rape. Exception 2, yes, sorry. Okay, for the offense of rape. Okay, now any specific reason? Okay, that always remember there are 10 to 11 grounds where actually the court sees whether they have to they can grant bail or not. They also impose the condition that in the bail you will do this. We are granting you bail, but you have to do this, you have to comply with the procedures. And the court actually sees few things, that whether the person will jump the bail or not. Jump the bail means if the person abscond, what actually happened, that it comes on the it ruins the track record of the judicial officers also. That is why even the court of session in the heinous offences, or the court sees that okay, it sees a repeat offender, that court usually what they do is they reject the bail. Why? They said that fine, go to the high court and apply for the bail. That is the and the court sees that whether the person will abscond or not, whether the person will try to temper the evidence or not, whether the person will will participate in the investigation, or whether the person will not threaten the witness of the or the complainant of the case. The court sees all such parts, and if the court is convinced, or if the court feels that okay, now it's 7:30 actually. Aditi, I'll request if we can extend the time for 10 to 15 minutes more. Okay. So in such cases, what will happen? That the court, if the court is convinced, then the court may grant the bail, or the court can reject the bail. So now we are done with this section 430. This part. Now please open your negotiable instrument act, section 138, and now let's take small break for 1 minute. Okay. And just to ensure that whatever you have learned as of now, it was fruitful to you. I have given you, to the best of my ability, the correct interpretation of the verdict, how the verdict should be interpreted, and how it should be taught. So thumbs up if you have any doubt. means if you have understood on the comment section. In the comment section, thumbs up if you have understood. Everyone. Okay, and if you have any doubt, please, this is the time. Any doubt? Okay, why it happens that date on date keeps on appearing, but decision doesn't come. It also depends how the trial is being conducted. Okay, it's a very subjective answer. Means there is no one-liner for this part, Lokesh. Any doubts? What does this line means? Manvendra Kushwaha. Which line? Manvendra? Okay, you can please write it on the chat box. I'll read it definitely. And section 436 again. Well, the third line says by an officer in charge of a police station or appears, or if he appears before the court, or if he is brought before a court. What do you have to understand in this part? At any stage can be, it can be a stage where if a or any stage means, see what happens. First the complaint is filed. Okay. Now if it is a criminal case, then the trial starts. That first there is a collection of the evidence, then the evidence are recorded, then the prosecution starts the opening statement, then it is the defense, and then when the trial starts, it is first the if you have done the internship, you must have found PW and CW. DW, sorry. PW means prosecution witness, DW means defense witness. So if the prosecution brings a witness, the prosecution first becomes the examination in chief, and then it is cross-examined by the defense counsel, and then if the court allows, then the prosecution is allowed to re-examine also, and then the defense brings his witness. There he becomes the examination in chief, because he is letting the statements to be the statements are given at the first instance, so he opens the case where the defense witness are brought to the court, and then such defense witness are cross-examined by the prosecution. Okay, so this is the trial stage, and then the court gives the judgment. In this entire stage, it is called, it can be the trial is completed, and when the trial is completed, the court gives his judgment. So at any stage means it is from the any stage. Okay, in before this stage, what happens? The complaint is filed, then the police files the charge sheet, and now in the charge sheet part also there comes two things. If the police feels that the accused has committed an offense and has got evidence to support, then the police records all the evidence and submits in the form of charge sheet. Okay, and if the and if the police feels that the accused has not committed any offense, and the case was it was a false case which was being filed, then the police files a closure report. Then against such closure report, the complainant, the victim will say, like suppose there is a rape victim, for example. The rape case is being filed, the police files, instead of charge sheet, the police files a closure report that the accused from whom we have arrested, there is no case being made out against such accused and we didn't find any evidence against him. So we are closing the case against the accused. That's where the complainant, the rape victim and the complainant has the right to file a protest petition. And the protest petition is filed. Always remember, please make it a note somewhere. The protest petition is filed in the same court where where the closure report is submitted. So I just hope again you have I'm not sure that you must have heard about the protest petition part. I'm not saying that before this class, but usually the concept of protest petition also does not exist in our law school syllabus. You always come and in Hindi, protest petition is also called Narazi Yachika. Okay, so in this stage, this entire stage of trial, the bail can be taken at any stage. Okay, now please open section 138 of Negotiable Instrument Act. Now, I'll give you a very small gist because we are running out of time and you won't believe, but for section 138, I actually always, in the course also, I always take at least 2 to 2.5 hours to teach what is the basic. Yes, IO has the power to close the case after the registration of the FIR because IO will do two things only. Either he will close the case or he will submit the evidence. Like suppose, for example, Lavkesh, I file a false case against you that you have committed a murder. The IO shall investigate and you'll find the alibi or any evidence that Lavkesh, if I filed an FIR that on 11th September at 7:39 p.m. Lavkesh has committed the murder of person X, then the police will start the investigation, and in their investigation the police will find out that okay, Lavkesh was attending a particular class at the same time, so there was no chance that the Lavkesh has committed a murder. Okay, Lavkesh has committed the murder. In that case, the IO will submit the closure report. Okay. Now, and in the protest petition, but don't worry, the police investigation, if you go through the course, the structure, you can see how many hours I have allotted for the investigation part. Okay. Now, section 138 of Negotiable Instrument Act. Now, what actually happens? See this. First, let me give you a very brief example. Res judicata means what? Res judicata means if there are two parties, same party means X versus Y, same party for same cause of action for the same case. Okay, same cause of action can be where the question of law was same, like it can be a check dishonor case or no, not check dishonor case because it becomes a criminal case. Suppose if it is a land title holder case, like who is the if you have to decide who is the title holder case, who holds the title, okay, and if the case has been filed and it is heard and decided, you must have come across these two words, heard and finally decided. Heard means the case was heard on the merits and the case was heard on the technical grounds also. Now, what is technical ground? Again, I'll explain in coming 5 minutes. In both the cases, if the same court, and that too in the same court, means suppose if it is a check dishonor case, the case will go in the court of JMFC Why? Because in the check dishonor case, the punishment is up to 2 years, and JMFC can give punishment up to 3 years. Then the case will go in which case? In JMFC case. But again, keeping specifically the check dishonor case apart, like suppose in a civil case where the civil court junior division had a jurisdiction of 50 lakhs, and the question on the same fact, like suppose there was a suit for recovery of 30 lakhs, then which court has the jurisdiction? Civil judge junior division has the jurisdiction, means the court has the jurisdiction. The court heard the case on its merits and on the technical grounds also, and the court has decided the case also, means the court has given its decision. Then you cannot file the same case again in the same court. This is the concept of res judicata, means no trial for the same case twice. Now, can anyone elaborate and enlighten me that similar provision also exists in CRPC also? And which fundamental right actually empowers the lawmaker for make such a provision in procedural law is your Article 20, means which talks about no double jeopardy. So Constitution is the main. And in the syllabus, I have told you that entire Constitution and course, entire Constitution will be covered. Constitution of India, Article 20 says there shall be no double jeopardy. Means a person shall not be convicted for the same offence twice. But in civil case, the same provisions are then used also, and the concept of res judicata was kept intact in CPC 1908. Okay, that there shall be no litigation for the same case twice. Like suppose if a civil case junior division has given a judgment, then the case will not be filed again in the civil judge junior division, but it will be filed in the way of appeal, means in the higher authority court. Via higher authority court, it can be your district judge also, it can be we'll go into detail during the course, it can be your civil judge senior division also, or it can be your high. Okay, now so I just hope this is clear what is in basic what is res judicata. But now I'll give you a very simple example. Now understand this part. There are two persons, X and Y. Y takes a loan of 1 lakh rupees from X. Understand this part. Y takes a loan of 1 lakh rupees from X, and as a surety, Y gives a check. Y gives a check to X. Okay. Now, X after and then they have an agreement that after after this period, the Y will return the money, and then X will return the signed check. Always remember signed check, because I remember there was a case of one of my friends that he said that Rahul, this has happened. Actually, I had taken check. I had taken the check, although the date is never mentioned in the check. Why? I'll explain again. I have taken the check from that person. The person has taken money from me, and now he's not returning. So I was like, fine, deposit the check in the bank. We're like, no, Rahul, actually the problem is, the checks are not signed. We're like, wow. Then I told him that why don't you give the same amount of money to me also, and I'll also give you unsigned check. Okay, and trust me, because we are school friends, then I'll definitely return your money within 2 to 3 years. Why 2 to 3 years? Because the amount was huge. Amount was close to 18 lakh rupees. Okay, so always remember this part, that please, if you are if you are taking check from someone against the loan you have given, then just ensure that you take a signed check, and the date should not be mentioned in the case in the check. Now, why? Because now again coming to the same example. X and Y. X has given 1 lakh rupees to Y. It can be cash also, and Y has given a check. Okay, so negotiable instrument comes into the picture. But suppose has not given Y has not given a check, and now there are two college buddies, X and Y. They are both first year BLLB student. Forget check dishonor part. I'll come after 5 minutes. They are two college buddies, BLLB students. Now A and B, there are two students. B says, just give me 5,000 rupees loan. No, not 5,000. Okay, give me 10,000 rupees loan. And in next month, when my pocket money will come, I'll return it to you, because in this month I have got these many important things to do, and please give me a loan. So A gives a loan of 10,000 rupees through Google Pay. So A has a proof that he has given money to B, 10,000 rupees. Now, 2-3 months have passed. Now B is not giving back the money. Then what will A do? I mean, apart from fighting, okay, apart from fighting and abuses, A has the right to file a suit for recovery. Against B. Okay. Why? Because he cannot establish this fact that it was a cheating. Why? Because he has not sold any product, or he has not induced the person. Or if you read the essential of section 415, which talks about cheating, or section 420 of Indian Penal Code, then that was not the case. It was a simple loan which was taken, and now because of any reason, B is not returning 10,000 rupees. So mens rea is absent, and when the mens rea is absent, then it is not an offense. It's a civil case. Even if you go to the police officer, it's what can we do? It's a civil case. Go and talk to the father of B. Maybe father of B can give you 10,000 money at one go. Why? Because a student, how can a student who is not earning can give you 10,000 rupees? He cannot. Okay. Now, A will do what? A will file a suit for recovery against B. Now, two things arises. How and where? So first, A will go to the court. He will go to the Court of Civil Judge Junior Division and see whether the Civil Judge Junior Division has the pecuniary limit. Pecuniary limit means the amount of money, the limit which the court can look into the matter. Now, suppose, let's take an example, Civil Judge Junior Division in that district or in that state has a pecuniary limit of 5,000 rupees only. So, A cannot file a case of a suit for recovery under Order 37 against B. Are you getting it? So, where will he go now? He will go to the Civil Judge Senior Division, and he will see whether Civil Judge Senior Division has the pecuniary limit or not. He will see that, okay, Civil Judge Senior Division has a pecuniary limit of 25,000 rupees. So there he is going to file a case. And how he'll file a case? First, he will see what is the court fees. And I hope you always remember, it is always approximately 8 to 10%. It again varies from state to state. He will see that, okay, for 5,000 rupees, the court fees is 700 rupees. So he will deposit the court fees. He will take the receipt, he will attach with his complaint, and then he will file the case in the court for court fees for 10,000. The amount of money was 10,000 rupees. Okay. So for 10,000 rupees, the court fees was how much? Suppose 1,000 rupees is the court fees. So he will deposit the court fees to the court, and then he will file the case. The court will accept the case and look into the matter, and then the court will send notice to the other party. Understood this part? Now, this is your simple suit for recovery case. Now, court fees part, let me give you another myth buster. You must have heard a lot of time that when you deposit money to the court, If you lose the case, the money is gone. If you win the case, the court refunds the money. This is a myth. The court never returns the money. Okay, the court never returns the money. But in the prayer, you will ask that you will pray to the court to direct the defendant to give my money back along with along with interest and also the court fees. Why? Because suppose the matter was not of 10,000 rupees, imagine, and it was 10 lakh rupees, and the person has deposited 1 lakh rupees as court fees. Then will he leave that amount? No. He will ask the court to get his court fees be given by the defendant, and the court will direct the person. The court will direct the defendant after listening to argument. If the court is convinced that the defendant is supposed to pay the money to the plaintiff, okay, then the defendant has to pay the money, principal amount, the interest, and the court fees. The court never refunds the fees, court fees. It is a mythbuster. And now suppose in your drafting part, because it's a drafting course, in your drafting part, in your main prayer, you have forgotten to write court fees also. That you have just asked that please direct the defendant to refund, not refund, to return the X amount of money along with, yes, except in the case, Lavkesh, except in the case involving offense against the state. Mens rea is absent, no offense, except for the sedition cases or for the cases where you are waging war against the country. Just wait. Everyone look into the chat box. Except in cases from section 140 IPC, where even in the preparation stage is enough for conviction. I'll give you an example. Suppose I want to murder a person X. I go to the market and I purchase a knife. I come home and then I decide that should I murder that person, and then I go to the market where he's doing the shopping part. Always remember one thing: criminal act, if completed, becomes an offense. But I threw my knife. Guys, I'm really sorry. Aditi, I was not told. I thought I'm the last guest speaker today. I'm really sorry, guys. I have to end the session because the time is up and there's another speaker who is waiting. So I'm really will definitely meet next time and I'll finish this part. Okay. So thank you very much.
Thank you so much, sir, for your valuable comments. So I think, sir, you are one of the favorite speakers here. And now I'd like to call upon Divyanshu Bhatt, sir. When I talk about Divyanshu Bhatt, sir, he is one who is practicing since 7 years, and he is an independent advocate and arbitration counsel. He is practicing at the High Court, Adjudicator of Allahabad and Lucknow bench. He is a modern-day legal professional who specializes in commercial disputes handling and is adept to identifying and handling the various commercial concerns of the clients. So sorry for keeping you waiting. So topics to be covered are the concept of limitations. So now I'd like to handle this session to Divyanshu.
Right. Hello everyone. My name is Divyanshu. Thank you for the kind introduction. Am I audible to everyone? Just a thumbs up from someone would be nice. Great. Okay. So I'll try and wrap this up quickly because I believe you guys have had a tough past couple of hours with a lot of information coming your way. So the topic that I'll be dealing with briefly is the law on limitation as it exists today under the Indian legal regime, right? Um, so moving on, cutting to chase down, the law of limitation in this country is governed by a plethora of provisions, but the primary act or the primary law on this subject is actually the Limitation Act of 1963. Now, the Limitation Act of 1963 is now, before I jump into this entire topic, it is important for you guys to understand that what is limitation. Limitation is nothing but a bar on any person to approach a court, either at the court of first instance or in the case of appealing against an order before the High Court or the Supreme Court or any appellate authority under any particular law per se, and for how long, as in terms of time. In terms of time, what is the bar that restricts that person from filing the suit, the petition, or the appeal before any court? So, law of limitation is strictly for the purposes of ascertaining the time or the time of validity when that particular suit, petition, or appeal can be filed. Once we are clear with that, now we come to the provision that is applicable. And for this, I don't know if you guys have access to the Limitation Act of 1963, but I'll project the relevant sections for your reference as we go along. However, it is important to understand first things, like the basic principles first. The law of limitation provides that any person can file a petition or a suit or an appeal before any court of law up until a certain time period only. And that time period varies depending upon the kind of suit or the kind of petition or the kind of appeal it is, or at the stage where the particular proceeding is at. Therefore, it is important to first understand, and I hope if you can note down the first important section for you guys to understand this entire concept is section 2J of the Limitation Act 1963. Section 2J defines what is period of limitation. And what I can do is, if you want, I can project the relevant section. Just give me a moment. So this is the provision. This is the act. We'll go straight to the relevant sections, and I'll try and keep it as easy and simple for you guys. So the section that we are referring to is this. Section 2J, period of limitation. Period of limitation means the period of limitation prescribed for any suit, appeal, or application by the schedule. And prescribed period means the period of limitation computed in accordance with the provisions of this act. Now, there is a reference to something called the limitation period prescribed for any suit or application by the schedule. Now, what is this schedule? The schedule actually comes at the end of the Bare Act, and it provides the periods of limitation for different kinds of suit under section 2J. Now, if you go through this, and I will not go through everything, but just to give you a brief overview, it deals with suits relating to accounts. Part 2 relates suits relating to contracts. and so on and so forth. There are 7 or 8 parts of it. So, for instance, that if I may read the first one, the suits relating to accounts, the balance due on a mutual open or current account, where there have been reciprocal demands between the parties, the period of limitation is 3 years. Which means what? That when do you, the date on which the cause of action arose, from that date, within 3 years, you need to file such a suit before the concerned. Now, so far it seems very simple that within 3 years you can approach. And similarly, there is a varying degree of how soon can you file or what is the period of limitation in respect of each kind of suits, petitions, appeals. The problem that arises in this case or on the law of limitation generally, and this is the primary point of concern in respect of various case laws, is that when there is a period of limitation prescribed under the Limitation Act, and there is also a period of limitation prescribed under any particular statute. You can name any random statute to me, any particular law dealing with IPR, dealing with arbitration, dealing with everything for that matter, wherein a particular time is prescribed within which you have to file a particular application or a particular appeal. Now, say for instance, in the case of arbitration, a section 34 application before, which is basically to set aside the arbitral award, needs to be filed within 90 days or 3 months. So now the question arises that there is a time period prescribed of 90 days under the Arbitration and Conciliation Act of 1996. And there is also a time period prescribed for such kind of suits under the Limitation Act. Now, do they operate in conjunction with each other? Do they overlap? Or what takes precedence? What time period is the actual time period? In this regard, the law has been settled, and there are a plethora of case laws. The latest one being this case of Bhagwan Das versus British Airways, which says that the provisions under the Limitation Act of 1963 do not supersede, but are rather only applicable when the particular law or the act does not provide a period within themselves. This means what? That if there is any particular law that provides that there is a certain time period within which you have to file an appeal or an application or a suit or a petition, then that time period is the one that is applicable and not the Limitation Act of 1963. Now this is very interesting because this is where most of the issues arise, because the primary issue or the dispute becomes that what is the time period that becomes applicable. But to that extent, the law stands settled in our country because the courts have repeatedly held that when there is any time period prescribed by any particular statute for filing any suit, any appeal, any application, then that time period takes precedence over any other time period that is prescribed by virtue of the Limitation Act. It is only in the scenario that when there is no time period prescribed under any act or any statute, that the provisions under the Limitation Act of 1963 are coming into play. Otherwise, to the extent that the time period is prescribed under any particular special statute or act, the provisions of the Limitation Act 1963 stand excluded. Is there any question so far on this applicability of the time period of limitation in front of anyone? If you have any questions, just type them out, just throw them at me in the inbox, in the message chat. and also because this interpretation has come about on the basis of section 29(2) of the limitation. And for your convenience, let me show you what that section says. Section 29(2) of Part 5 of the Limitation Act 1963 says this. It's the savings clause. It says, where any special or local law prescribes for any suit, appeal or application a period of limitation different from the period prescribed by the schedule, the provisions of section 3 shall apply as if such period were the period prescribed by the schedule, and for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local law, the provisions contained in section 4 to 24 inclusive shall apply only insofar as and to the extent to which they are not expressly excluded by such special or local law. Now this is very interesting. This last part says there should be an express exclusion. This express exclusion actually means that it is not as if there has to be, say for example, as I gave you the example of the arbitration. Arbitration Act says, section 34 says that the application for setting aside the arbitral award needs to be filed within 90 days. It nowhere says that the periods prescribed under the Limitation Act are excluded. But the courts have interpreted this to mean that even if there is no express exclusion, even if any particular law only prescribes a time and does not exclude any other time period, even then that counts as an express exclusion. So to that extent, the law on this subject stands fairly settled. Now now that I have explained to you the entire regime of the Limitation Act, there is something very interesting that happened in our country in the past 2 years, and that is COVID. Right? So what COVID did was that the whole country was shut down for a long period. People were not even able to get out of the house. There were public institutions that were shut down. In fact, a lot of us suffered the complete shutdown of the local machine. And the judiciary was no different. The judiciary also suffered the same setback. The courts weren't open, the courts weren't functioning, no one knew how to function online. I'm talking about, remember 22nd, 23rd March 2020 when the whole country was just shut down. Judiciary was also shut down. So in such a scenario, if the time periods prescribed under any law were to be given effect, the whole country was shut down for 2-3 months at a stretch. In 2020, in 2021, every time the first wave, the second wave, the third wave, I mean, now we don't even have a track of how many waves has it been. But the important thing is that the Supreme Court took cognizance of this situation and said that we understand that there is a difficulty for not just the courts, but for people to be able to approach the court and exercise their right to file a suit, a petition, an application or an appeal. Therefore, during such period of hardship which the country is going through, from March 2020 up until May 2022, the entire period stands excluded from any limitation. Which means what? That if, say for instance, there was a dispute that arose in February, you had say 45 days to file an appeal under any law, and that period was expiring on, for instance, 30th of March. Okay. The period beginning from 22nd of March till May 2022, as per the latest orders, stood excluded, which means that even if your period of limitation was expiring, or the clock of your limitation, as we call it, was running out on any day, even one day after 22nd of March 2020, and you have not filed any petition, that particular petition, suit, application up until May 2022, even then you are allowed to go ahead and file it after May. Now this is something which is unprecedented in the country, which this country in its 75 years of independence has never ever seen. That the right of the people, the right of any person who is aggrieved by anything to file a suit, a petition, an application, an appeal, or to be able to approach the court to raise any grievance that they have against any order, against any misdeed, against anything, all of that stands excluded. So you're remaining, say for example, as I gave you an example of 30th of March, so only 8 days were left. So those 8 days will be counted after May 2020, not in time. Now this is something incredible and something new that the whole country had to go through, and Supreme Court had to take cognizance of this. Of course, they were bound to take cognizance of this and give relief, because otherwise it would have been very unreasonable to people to go ahead and make sure that the time period of limitation, or bar anyone from approaching court by enforcing any reading of the period of limitations prescribed under any statute. Because when the country is going through so much, how can you expect people to come to court, pursue, engage an advocate, consult, draft a petition or a suit or an application or the appeal, and go before the court and fight for their rights? When there is such a problem existing in the country. But even in such a scenario, the Supreme Court deemed it fit, and suo motu took cognizance of this entire situation and decided to give relief. And this is of significance, because in this country, this is something that has never ever happened. So this is a brief overview of the law of limitation in the country, and the interplay between the law of limitation as it stands in front of you and any other law as it stands in the country as of today. Do we have any questions? Because the law of limitation is a very limited aspect of pursuing your legal rights. And the idea is that while on one hand, the consideration is for everyone to go ahead and be able to pursue their causes of action before any court, you have a right. That right needs to be exercised within a limited period. Otherwise, you can't be sitting on your right for times to come, for forgetting your rights, and like for 10 years, 5 years, 10 years, or an unreasonable period of time, and just not pursuing it. And even then coming to court and saying, oh no, mere ko to 1980 in 1980 I had suffered this wrong and I need to be given compensation. You can be reasonably barred from raising such dispute, because there can't be an endless time for you to be able to pursue your rights. But COVID was such an exception, which the court deemed fit in the interest of justice for people. So if you have any questions, please fire them away. Or you have any particular fact situation which you would like to discuss as an example of why the law of limitation exists, and if there is any bar against any kind of person from pursuing any right before any court of law. So if there are no questions, okay, great question. Is there any time limitation for a PIL? Now, you need to understand this. What is PIL? A PIL is a public interest litigation, which means what? It is a cause of action, or it is a problem that is suffered by a lot of members of the society. And some concerned citizen or a public spirited person, in the words of the judgments of the Supreme Court, raises that issue before the court, before any writ court, the High Court, the Supreme Court, and pursues that cause of action for the good of the entire society. The idea is that till the time that issue continues to be valid, there can be no time bar against it. I mean, say for example, if there is an order that has come, or if there is a particular decision that has been taken by the central government or the state government or your TM or anything, that affects a large section of the society. Till the time that that order continues to exist, you can go ahead and make a reasonable plea before the concerned High Court or the Supreme Court for this purpose, pursuing this cause of action. However, it can't be that there is a law that, or there is an order that you were yourself aware of for all these time. Okay. So why Limitation Act introduced, Act working effectively? So as I was explaining to you, suppose you suffer, say for instance, you get into a dispute, X gets into a dispute with Y. X lends Y some money, Y refuses to pay it back. Now there is a dispute, X wants to recover his money. What does X do? X can go to a court, a civil court, and file a suit for specific performance. Must return my money. Okay. But X just doesn't do it. For 5 years, 10 years, X is just sitting. Limitation Act was introduced to curb this menace and make people more responsible towards pursuing their actions. So when you choose not to pursue your right, it is counted as a waiver of your right after a certain period of time. Now what is that reasonable period of time is something that has been prescribed in the Limitation Act as well as every particular statute under which you have the right to pursue a relief. Now, of course, there is a discretion with the court that there can be, if there is a delay or a reasonable delay, say for example, if you had to file that suit within 3 years, as we read in the schedule, you did not file that suit within 3 years. You approached the court after 3 years, 6 months. The court asks you, why were you sitting, boss? Why did you not come earlier? Then you get up and tell the court, boss, I wanted to pursue this case, but I couldn't pursue it for some reason or the other. The reason being a death in the family, you not being able to track the accounts, you not being able to, you encountering some bad legal advice, or you pursuing that action in a different court or a wrong court where you were not entitled to pursue that. But if it's a bona fide reason and the delay can be explained, the reason for that delay can be explained in a bona fide manner, then in that case the court does have a discretion to excuse a certain period of reasonable delay. Is there any penalty or fine for delay even having a reasonable cause? Okay, so this is where we venture into what you call typically the discretion of the court. So it is completely within the right of the discretion of the court to adjudicate when a reason is given for explaining that delay and whether that delay is legitimately explainable. The court may completely accept your reason. Say for example, someone's father took a loan or lent someone some money, but that person did not repay that loan to their father. The father was the person who was aggrieved and should have filed the suit, but the father somehow unfortunately passed on. The son doesn't know about it, or the daughter doesn't know about it. It's only after a period when they go through the bank accounts of the father and everything, they discover that something like this their father had been wrong, and they wanted to recover what was legitimately belonged to their father. Then in that case, it's a legitimate reason, and the court may accept it. But there can be equally a scenario where the court deems that you have no justifiable reason for such delay and may bar you completely. Then comes the period in between. That say for example, the court thinks that your delay may be a reasonable, that your delay may be explained, but it may not be a completely justifiable reason for which which contributed to the delay. In which case, the court may ask you to deposit some nominal amount as a fine, or you know, or for that matter, to be able to allow you impose a penalty, so to speak, so that you are more informed of your rights and pursue your rights in time. They can go ahead and impose a penalty. That's completely within the discretion. To answer your question, Lavkesh, is it applicable in J&K? Not until the Act of 2020, when J&K, until the time that J&K was a state. But now it is. It also extends to the state of J&K with certain exceptions. That is a more jurisprudential and constitutional question and would require a larger discussion. But yes, it does extend now to the state of J&K as well. To the union territory rather, I should say. It extends to the union territory of J&K as well. Any other questions that anyone may have? Yes, that is true. Okay, so when law of limitation extinguishes the remedy, then House has right to exercise. Now, when you currently, if I understand your question correctly, when law of limitation extinguishes, you mean that I believe you mean that the period has expired. Is it correct that the period of limitation that has been provided has expired? Okay, great. So here is the tricky part, that when that period is expired, technically, strictly reading the law, you cannot exercise such a right. But if you come to section 5, now let me show you section 5 of the Act, which I was explaining to you guys earlier. Section 5 of the Act says, extension of prescribed period in certain cases. Any appeal or any application other than an application under any of the provisions of Order 21 of the TPC 1998 may be admitted after the time if the applicant or the applicant satisfied the court that he had sufficient cause for not preferring the appeal or making the application in such time. So currently, does that answer your question? Section 5, along with the explanation, right? Great. But as I said, that explanation is completely, whether or not to accept your explanation is something that is completely within the discretion of the court. Any other questions? Okay, so if there are no more questions, I'd like the organizers to take over from here. Thank you so much.
Yes, sir. Thank you so much.
It was an absolute pleasure, you guys. Thank you so much for giving me a patient hearing. And if you guys have anything else to ask or any doubts in the future regarding the subject or anything else, I will, here is my email ID, I'll put it in the chat box. And any of you can go ahead and just shoot me. I'll be ready. Thank you so much, guys. It's been a pleasure. Have a good night.
Thank you so much, sir, for all the valuable information you have given to us. It's a pleasure to have you to our bootcamp. Thank you so much, sir. So now we'll be having a small book launch. So the book launch, the title for this book is The Development of Victims, Right and CRPC, which is written by Deepak Anjana and Chetan Prakash sir, and who is the assistant professor at Indore Institute of Law. So to talk about this book, so in this modern criminal justice system, it is a state which has stepped into the shoes of the victims of the crime. As the crime against any individual or a group is considered as a crime against the whole society, and because of this, the state prosecute accused on behalf of the victims as well as society. So coming forward to the state in the criminal proceeding against the accused has various ramifications against the right of victims whose interests are least taken care of in the most of the criminal justice systems, including that of the India's, which focuses on towards the reparative justice keeping for the offenders at the center. So basically, the book is all about the victims of crime and the provisions of the Code of Criminal Procedure, and it dwells into the need of amendment in the statutory provisions for a better representation and protection of the victims of the crime. So I call upon the authors of this book.
Hello. Hello. Am I audible?
Yes, sir. You're audible.
Is background noise is too much?
A little,
Wait,
sir.
wait.
Now I. Thank you, sir.
Am I audible now?
Yes, sir.
Hello. So, first of all, I like to thank Mr. Amresh Patel sir for giving me this opportunity. This book, Development of Victims' Right to CRPC, is basically based from victims' perspective. Our criminal justice system has neglected victims. Uh, it is focused upon accused and on victims' behalf, it is the public prosecutor who fights the case. Basically, it is a state to step into the shoes of victims as soon as any criminal act happens or FIR is filed. So this book try to understand the plight of victims and the provisions for them in the CRPC, the provisions available for victims in CRPC, and amendments needed in the cater to the needs of victims. So, I co-author of this book is Assistant Professor Chetan Prakash. We both have tried to uh, cover as much points as we can from victims' perspective. And the book also goes through the Malimat Committee report, which talks about the need for changes in the criminal statute, including CRPC, so that they can accommodate the needs and needs of victims, so better justice can be served to them. So initially this book talks about the concept of victimology, how it grown as a part of criminology. Then it goes on to explain the victims' rights from ancient times, then medieval era, then modern era, and this book also throws light upon the statutes from several other countries, including New Zealand, which is considered as an ideal statute, criminal law statute from victims' point of view. So, and towards the end, this book throws light upon the provisions of CRPC and what are all provisions given under CRPC regarding victims, and what more can be done through amendment, and more laws can be amended so that they suit the needs of the victim. So we tried our best to showcase the plight of victim, which is generally ignored in our criminal justice system, as we follow a part of common law system, follow adversarial system, so in which the victim is totally neglected. So this book tries to explain from their point of view, and it also has numerous case laws, including like the Bodhisattva case and all, in which the judiciary has time and again throw light upon the need for amendments and the criminal statutes, like majorly CRPC, so that the victims can get more rights and just access to justice can be easily available to them. So this is all about the book is, and we hope that it makes the law students better understand the CRPC from victims' point of view also.
Thank you so much, sir, for all the valuable information you have given us. And also, thank you so much for enlightening on this book. Thank you so much, sir.
Thank you so much. Thank you all. And I especially like to thank Amresh Patel sir for this opportunity. Thank you, sir.
Thank you so much, sir. I'd like to thank all the participants who have participated in this bootcamp, and hoping that everyone present here has got valuable information. So I'd like to call upon Amresh sir for the closing words.
So hello everyone. How are you people? First of all, I'd like to thank everyone for joining the session. And obviously, we'll be sharing you the feedbacks about it. We'll be sharing you feedback form. Kindly provide your feedback in the form itself, so that we may keep on improving our sessions, the delivery of it, quantity, content, and all. Also, you people already know that we have already launched a course on litigation course, particularly for drafting and litigation skill. This course will be teaching you about the techniques, procedures, and methods for drafting and litigation as well. So you'll be getting insights from experienced advocates and also from the judges, the sitting bench of the judge. So we'll be getting lots of insight from experienced faculties, experienced judges, experienced advocates. Join the session, join the course as well, because that will be beneficial for you. About this particular bootcamp, do provide us your drafting competition. Obviously, will be coming up with it. Probably in the month first or second week of October, we'll be launching it. So don't have to worry for it. Probably from Monday itself or Tuesday itself, we'll be launching the brochure and other details for it. Team will get back to you. About this particular session, do share your feedback. It help us in improving our session. We have already launched this bootcamp on YouTube. So join that particular. If you any of you have missed following content or have missed something on it, you can visit our official into legal platform, and you can watch it over there also. All the best participants. Wish you very good luck in the future.
Thank you so much, sir, for your valuable comments. So, as a formal word of thanks, I'd like to thank the speakers, Advocate Rahul Tiwari, sir, Dhyanshu Bhatt, sir, and Tanay Hazari, sir, for taking time from their busy schedule and giving us valuable information. So, I express my gratitude to everybody for cooperating from this beginning to the end, and it's amazing to have participants like you. So, I would like to thank all the members of Interlegal World who are a source of inspiration and worked for the success of this event. And hence, we shall mark the end of this bootcamp. Thank you so much for joining us.